Hey everybody, News Now Wyoming, bringing you another case update. This is one that a case that we covered. This is here local to me. This is Bryant versus a bunch of stupid deputies. So in the video that was released to the news media, which is the body camera of the deputies, they went up to a house to do a welfare check on somebody. And when he refused to show them his arms, they immediately tried to grab him, and he went into the house. And then they followed him into the house to arrest him for his own good, of course. Now, the problem is, first they never told him he was under arrest before they followed him into the house. They never... and then they never actually took him to the hospital. So if you're concerned somebody is going to harm themselves, your next logical step is to take them to the hospital. So of course, and where I said in my original video, I did not see Monell claims in this lawsuit. I did not see where it would survive a Monell claim. They didn't argue very well in the complaint, and the judge apparently is... confirms my opinion that it was not a very strong Monell claim against the Board of County Commissioners. Oh, excuse me. So, in this order granting judgment on the pleadings, Alright, this matter comes before the court on the defendant's partial motion for judgment on the pleadings and supporting memorandum. Plaintiff Devin Bryant filed an opposition, and defendants replied. Having considered the parties' arguments, reviewed the record herein, and being otherwise fully advised, the court finds the motion should be granted. So standard for 12C motions for judgment on the pleadings. Motions under a 12C, which is the rules, the federal rules, motions to dismiss for failure to state a claim under 12B6 are reviewed under the same standard. The complaint must give the court reason to believe that this plaintiff has a reasonable likelihood of mustering factual support for these claims. The court accepts the non-moving party's well-pled factual allegations as true, but is not bound to accept an asserted legal conclusion as true. Defendants here seek partial judgment on the pleadings based on statute of limitations grounds. 12C motions serve a particularly useful purpose if the applicable statute of limitations would bar a party's claim and result in dismissal of the entire controversy as a matter of law. It is appropriate to resolve a statute of limitations defense on a 12B6 or 12C motion when the dates given in the complaint make clear that the right to sue upon has been extinguished. Complaints allegations. In January 2020, Mr. Bryant was sent an email to his estranged wife that said he had cut himself. Mr. Bryant's estranged wife reported the email to the Laramie County Sheriff's Department because she was worried about Mr. Bryant. About 2:45 a.m., about 9 hours. Yes, you guys, they were so concerned that 9 hours later at 3 in the morning, they come knocking on the door. Kiss my ass, deputies. Don't be knocking on my door at 3 in the morning. About 9 hours after Mr. Bryant had sent the email, Deputy Ryan Lee and Deputy Jason Gilliam went to Mr. Bryant's residence to perform a welfare check on him. He and his mother came to the door. They stood inside the doorway with the screen door partially open while the deputies stood outside on the deck. They explained they were responding to his wife's report, and Mr. Bryant told the deputies he had sent the email to her a couple days ago, but said, "I'm fine." Deputy Gill then asked to look at Mr. Bryant's arms, and Mr. Bryant declined. He said he understood why the deputies were there and told them, "I'm good." He again asked Mr. Bryant to see his arms, and Mr. Bryant again refused. He stated, "I don't want to show you anything, and I don't need to." Deputy Lee then told Mr. Bryant, "Yes, you actually have to at this point." Mr. Bryant again refused, saying, "No, I don't." He then swung the door open, reached into the home to grab Mr. Bryant's arm and shirt, and tried to pull him out of the house. Mr. Bryant resisted and said, "Get off me," while his mother pleaded with the deputies to stop and yelled for her boyfriend to come to the door and help Mr. Bryant. Deputy Lee kept trying to pull Mr. Bryant out of the house while Mr. Bryant resisted. Deputy Lee also yelled at Mr. Bryant's mother to stay back, and he physically pushed her back. Deputy Gillen then entered the home, grabbed Mr. Bryant, and the two deputies together pulled Mr. Bryant out of his home onto the deck. I want to make sure it is clear they never said you are under arrest. By crossing over that threshold of the home, is this a lawful arrest? And the answer is hell no, it's not. And yes, they did violate his rights. Mr. Bryant's mother followed them outside and yelled, "Leave him alone." Without warning, Deputy Gillett tased Mr. Bryant's mother. He also tased Mr. Bryant, despite the fact that Mr. Bryant was already being subdued by Deputy Lee. Mr. Bryant was then handcuffed and arrested for resisting arrest and taken to the local jail. The district attorney promptly dismissed the charges against Mr. Bryant. He now sues both deputies as well as their employer, Laramie County, and his First Amendment complaint asserts 4 claims for relief. 2 under 1983 for deprivation of his Fourth Amendment rights, and 2 alleging state law negligence. His state law claims are pled under the Wyoming Governmental Claims Act, which waives governmental immunity for certain conduct by government officials and holds the employing governmental agency liable for payment of damages. Defendant's current motion seeks judgment on the pleadings on the state law claims. The rule in diversity cases that the federal court also applies when a federal court exercises supplemental jurisdiction over state law claims in a federal question lawsuit. Mr. Bryant says his 2 state law claims sound in negligence. In their motion for partial judgment on the pleadings, defendants contend Mr. Bryant's assertions actually allege 1 or more intentional torts, assault and battery, and he filed this lawsuit after the applicable 1-year statute of limitation had expired. Does this say when he filed? No. So this happened in January of 2020. There are 4 elements a plaintiff must prove to establish a negligence claim under Wyoming law. The defendant owed the plaintiff a duty to conform to a specified standard of care. The defendant breached the duty of care. The breach approximately caused injury to the plaintiff, and the injury is compensable by money damages. An actor commits the intentional tort of assault in Wyoming where he acts intending to cause a harmful or offensive contact with another person or is in imminent apprehension of such a contact, and the other person is thereby put in such imminent apprehension. And then tort of battery. Remember, assault and battery are different. He acts intending to cause harmful or offensive contact with another person or imminent apprehension of such contact, and a harmful or offensive contact with the other person directly or indirectly results. Mr. Bryant calling his state law claims negligence does not necessarily make them such. Of course, a mere allegation of negligence does not turn an intentional tort into negligent conduct. And that's a 10th Circuit, so they have to follow it. To determine the nature of an asserted claim, we focus not on the label the plaintiff uses, but on the conduct upon which he premises his claims as supported by the record. One of the key distinctions between claims sounding in negligence and those sounding in intentional tort, like assault and battery, is that the latter requires an unconsented touching. The absence of consent is inherent in the very idea of those invasions of interest and personality which at common law were the subject of an action for trespass, for battery, or assault. Under Wyoming law, negligent conduct is by definition not intentional. Intent is not a factor of negligence, since negligence precludes intended conduct. There is no such thing as negligent assault or negligent battery. Consistent with the Wyoming's civil pattern jury instructions quoted above, intentional torts generally require that the actor intend the consequences of an act, not simply the act itself. Mr. Bryant's state law claims do not describe negligent conduct by the police officers. They describe intentional conduct aimed toward and achieving specific consequences, including placing Mr. Bryant in fear and harmfully physically contacting him with their hands and with the taser. He describes his state law claims as follows. A peace officer had a duty of care towards Mr. Bryant, and that Mr. Lee breached that duty by violently ripping Mr. Bryant out of his home and tasing him without legal justification, and this breach caused Mr. Bryant damages in an amount to be determined at trial. He also alleges that when Mr. Deputy Lee started trying to pull him out of his home, Deputy unnecessarily escalated this respectful conversation into a threatening and dangerous confrontation, which scared him. Deputy Gillett then entered the home, grabbing Mr. Bryant by his arms and shirt and yanking him. Together, they violently ripped him out of his home while he was already being subdued by Deputy Lee. Deputy Gillett tased Mr. Bryant. Mr. Bryant concludes clearly Deputy Lee was motivated by his anger that Mr. Bryant refused his commands. But Deputy Lee's instantaneous fury at Mr. Bryant was shocking and deplorable. Mr. Bryant's allegations describe purposeful conduct by the officers motivated by anger, intending to place him in immediate apprehension while harmfully and offensively grabbing him and pulling him out of his house against his will. He was completely taken aback and scared by the officers' physical conduct and did not consent to it, even struggling to remain in his home. And he repeatedly asserts the officers had no legal authority or justification for their conduct. In short, Mr. Bryant's account of the officers' behavior does not describe the careless performance of their duties. It describes a willful, intimidating, and offensive attempt to physically force them to comply with their allegedly unlawful demands. Thus, Mr. Bryant's third and fourth claims for relief allege one or more intentional torts, not acts of negligence. True. The statute of limitations for intentional torts expired before Mr. Bryant filed his lawsuit. In Wyoming, the statute of limitations for suing on a claim of negligence is 4 years, while it is only 1 year for assault or battery. Okay, Wyoming legislatures. This is fucking stupid. Say that again. This is fucking stupid. Statute of limitations for suing on a claim of negligence is 4 years. So negligence is accidentally doing something, not doing something on purpose. Whereas willfully doing something is 1 year. What world does this make sense in, you stupid lawmakers? Tell me that right now. What world does this make sense? I understand that's the law. That is what you stupid cronies created as the law. So Wyoming legislatures, this needs to be fixed. This right here. In his amended complaint, Mr. Bryant alleges the events surrounding his claims occurred during the morning hours of January 28th. He filed this lawsuit February 1st. So yes, it is after 1 year. I do not doubt that. 1 year and 4 days after the events in question. So yes, this is a true, the state claims should be dropped. Consequently, Mr. Bryant's lawsuit was filed beyond the 1 year statute of limitations applicable to the intentional torts of assault and battery. Therefore, Mr. Bryant's third and fourth claims for relief are time barred. There can be no escape from the bar of the statute of limitations applicable to intentional torts by the mere refusal to style the cause brought in a recognized statutory category. God, I hate to agree with this. But yes, stupid legislatures, you need to fix this. And yes, I will be bringing this to some of their attention. Governmental Claims Act did not preclude him from asserting an intentional tort against the officers. It says his third and fourth claims for relief should survive because he was forced to ground his claims in negligence because under the Wyoming Governmental Claims Act, the state of Wyoming had not waived immunity for the intentional tort of battery. Were this accurate, still would not save his state law claims. The court would not countenance an attempt to avoid governmental immunity by mislabeling certain causes of action. But more than that, his argument is mistaken. The plain language of the WGCA waived governmental immunity for the tortious conduct of peace officers while acting within the scope of their duties. Given its ordinary and obvious meaning, the phrase tortious conduct in 139.112 encompasses a variety of tort causes of action, including intentional torts such as assault, battery, and false arrest. And that was a Wyoming Supreme Court case addressing an intentional tort, intentional infliction of emotion. The court agrees with the defendants that if the Wyoming legislature intended to limit the statute in the manner argued by Mr. Bryant, it would have used more restrictive language than tortious conduct, much like it did in Wyoming statute, where it expressly limited government liability to a governmental employee's negligence. The court must give operative effect to the legislature's choice to use more expansive language. Consequently, there is nothing to suggest Mr. Bryant could only plead a claim of negligence against the deputies under the WGCA. Allowing Mr. Bryant an opportunity to amend his state law claims would be futile. Finally, Mr. Bryant argues that he should be given an opportunity to amend his complaint to assert a viable claim under the WGCA. Court finds amendment would be futile. A proposed amendment is futile if the complaint as amended would be subject to dismissal. His assertions of the event set forth a claim deputies committed one or more intentional torts against him, and his complaint cannot be reworked to meet the applicable 1-year statute of limitations for intentional torts, leaving the claim still subject to dismissal. Therefore, the court denies his request for an opportunity to amend. And I do agree with this, you guys. That is what the Wyoming law says. That is what Wyoming law needs to be fixed. Conclusion. In the third and fourth claims for relief, his amended complaint sets forth state law claims pled under the WGCA. However, he filed this lawsuit beyond the 1-year statute of limitations applicable to intentional torts. Claims 3 and 4 cannot survive. It is therefore ordered that the defendant's partial motion for judgment on the pleadings is granted. It is granted in defendant's favor and against Mr. Bryant as to claims 3 and 4. It is further ordered that as no cause of action remained against the Board of County Commissioners of Laramie County, the board is hereby dismissed from this lawsuit, and his first claim of relief and second claim of relief remain pending against Deputy Ryan Lee and Deputy Jason Gillett in their individual capacities. So the lawsuit is not over. He still has 2 other claims of relief under the federal statutes, Section 42, 1983. So he can still win this. This is a major setback for him, but it's certainly not over yet. What do you guys think? Let me know in your comments below. What should the language of the statutes read? And if you live here in Wyoming, what are you going to do about it? I know what I'm going to do about it. What are you going to do about it? Let me know in your comments below. Hit like, subscribe if you like this content. Have a great day.